Now, when we start taking a look at sexual harassment, I think there's a fog area, and we're going to have a discussion about this in just a second. We start taking a look at sexual harassment, I think there's often a misconception. Can you ask someone out in the workplace? The answer is yes, you can. Can you be asked out twice? What if the second time they bring flowers? What if they bring chocolates? What if they have seen way too many chick flicks and they're trying to use all the different lines that they've ever seen in any of these movies and you're just not interested? Well, if you don't tell anyone except this person and say, hey, I'm not interested, and that's it. And they say again, and you smile and say, I'm not interested. Thanks, but no thanks. If you don't tell anyone, that is not a hostile work environment, because someone needs to know, so you got to be able to communicate it to someone, primarily management, that this is affecting your ability to do your work. So if you tell the person, hey, you're a creepazoid, you're creeping me out, I don't want you anywhere near me, but you don't tell anybody else, how is management supposed to know? And you might say, well, this is the manager. Well, there's still always someone else that you can contact, whether it's an HR or somebody else that's out there. And if it's the overall boss of the entire organization, you can file a complaint with the government. But oftentimes when we think of sexual harassment, it might not necessarily be sexual harassment. A popular case out there involved a firefighter in California. A female firefighter worked at the firehouse, and they had a number of magazines there because you live at the firehouse. And so they had Popular Mechanics, they had Sports Illustrated, and they had Playboy. And this was on the desk. And she sued, saying that created a hostile work environment. How many of you would say that's a hostile work environment? No, none of you? And the court said, yeah, it's not a hostile work environment. If they didn't do anything with it, it's out there as like other magazines in the living common area, that's not a problem. If they had posted posters up and said, you know, you could look like this, or this looks just like you, or things like that, then maybe. But just having it out there like any other kind of publication did not constitute sexual harassment. Let me give you another example, also from California. California gets the weirdest sexual harassment cases you can imagine. Okay, so this is a scenario. A 911 dispatcher is on the phone. Her boss, while she's on the phone responding to an emergency call, gropes her breasts from behind her, and she's trying to fight him off while she's talking on the phone and answering a 911 call. Is that sexual harassment? Okay, so let's say a showing of hands. Is that sexual harassment? No, it wasn't. That could be assault. It could be battery. Well, it definitely was battery. Assault is if she apprehended it or feared the contact. But the court said it was not sexual harassment. Why? Because in that context, what happened was he had done this before to a prior employee, but that employee left and didn't tell anyone. So management did not know that this guy had this proclivity or, that this is what he did in the workplace, this disposition. And so they weren't on notice. And so if they're not on notice and didn't have that warning, even though we might say it's the most offensive thing we've ever seen, that doesn't create legal liability. Now, of course, he was, disciplined, terminated, all that stuff, and she could file a criminal complaint and file a civil complaint against him. But the employer, if they did not know, that doesn't create a hostile work environment. So as we talked about before, quid pro quo, when submission to or rejection of sexual advances is a condition of employment, that is a very clear-cut case. And you see that very infrequently anymore. There used to be one of the big cases was another California case involving an attorney and his legal secretary. And he used to say, oh, can you fetch some change out of my pocket? He'd throw change and have her bend over to pick it up and stuff. Just stupid, sophomoric kind of behavior. And you can award punitive damages, and that's what happened with this law firm, which they weren't disciplining him. They were basically punishing her for raising it because he was a big money-making attorney for them. So they said while the case was being litigated, we found religion. We're now straightening out how we handle these things, and we're doing much better. Of course, this is back in the 1990s. when this case came about. And so the jury said, yeah, you found religion? Great. So in religious organizations, they tithe. We're going to have as punitive damages 10% of your income that year, which was in the millions, is going to go to her as punishment for what you guys did not do when she was complaining about this kind of conduct. And so that's something that's a real important part of this. Now, hostile work environment, for it to exist, you have to complain about it, and it has to be significant. If it's one person asked you out, and you go, that guy's a creep, or that woman's a creep, or whatever it is, and they ask you out once, that doesn't create a hostile work environment. It has to be pervasive, saying that affects your ability to do your job on a day-to-day basis. So I'm trying to remember which case it was. It was against a brewing company, and a guy was relating that he saw Seinfeld the night before. And in that Seinfeld episode, Jerry forgot the name of a young lady he met, but he remembered it rhymed with a woman's body part. And so this guy was saying this, talking about it, and he was terminated. Now, he had done other stupid things in the workplace as well, so this was like the quote-unquote last straw. He sued, and they were forced to rehire him because they said what he did didn't amount to being so significant that it represents a hostile work environment. Now, in the old days, it used to be that to be a hostile work environment, you had to have gone through like treatment or therapy or something like that with a psychologist or a therapist to show that you were harmed. Not anymore. What the courts say now is pretty straightforward. You don't have to prove that. It's called the Harris versus Forklift System case. And the Supreme Court said if it affects your ability to do your job,